Welcome to our weekly Zoom Q&A. We will get started as soon as everyone's in from the waiting room, which I think is probably about now. Just as a warning, we are light on questions today. We got 4 in advance. Some of them are faster answers than others. So if you have any questions that come to you while we're talking about some of these things, or a question that you didn't get in time on Monday, please put it into the chat and we will answer it if we can. As always, this is general legal information. It's not legal advice. Only your association attorney can give you legal advice. At times, we may say that you should contact your association attorney. That's if you want a more specific answer. We're just going to be providing general information here today. There is a chat function where you can put those questions that I mentioned we might have time for. Chelsea has already put in some additional information. The chat is intended for questions or requests for clarification and commentary. In the chat is not legal advice. Y'all are pretty good at keeping it professional in the chat, so we can move on. Also in the chat is a link for the Monday Morning Minute. This is the weekly update from the WSCAI Legislative Action Committee about what is going on down in Olympia. And it's a short read. If you want to get that information, you have to opt in. And it has updates as we approach the end of the legislative session, which I think is at the end of this month. Also in the chat will be a link for the WSCAI annual conference that will be taking place the 24th through the 26th. Several people from our firm will be presenting. Ken and I are doing a presentation on Ukiah and conflicts in old documents. Valerie will be giving an update on the legislative session, and we will have a booth. So we'd love to see you there. Stop by and say hi if you're around. And I think with that, we will jump into our first question. So the first question is, what is the process generally for when an owner wants to install solar panels? What do we do if the roof needs to be replaced? So first, this will depend on what statute controls. Older condos may have different rules. There are going to be differences based on where the boundaries of the unit are. So in some cases, an owner, and I'll get into it, may have a right to install solar panels on their roof. If it is within the unit boundaries. But there's a difference if the roof is outside the unit boundaries and it is part of the common elements. Those rights allowed by statute don't apply when it's for installation on the common elements. The board and the association may accommodate installation, but that's getting really specific as to whether or not you should. And we get into different styles of construction, and so it's going to depend on what your boundaries are. So you may have a townhome community where the boundaries of the unit include the roof, or you may have a townhome community where the roof is outside the unit boundaries. So you should contact your association attorney to figure out where those boundaries are. Only RCW 6438055 and RCW 6490510 require an association to allow an owner to install solar panels on or within the unit if certain conditions are met. These statutes can be used as a guide for what must be allowed, and the statute allows the association to require an owner to pay for extra costs incurred by the association for things like a roof replacement if the costs are caused by the solar panels. So with other things like an EV policy or an HVAC policy, we recommend having a clear written policy or having a signed and recorded agreement about what the expectations are. Sometimes we call this a hold harmless, and it can be something different. In all cases, you can require an owner to submit a request to the Architectural Control Committee and review what is appropriate. This goes for if it is within the unit boundaries on the roof or if it is on a common element roof. The statutes that apply are SOE 6438055 and 6490510 do specifically say that owners or residents who install solar panels must, and the association can require those owners to indemnify or reimburse the association for any loss or damage caused by the installation, maintenance, or use of the solar panels. If you have an owner who has installed a solar panel and you don't have any sort of written agreement or recorded document or policy, and the roof needs to be repaired, for example, that's when we recommend consulting your association attorney. But if you have a recorded agreement or just any agreement, that agreement should include indemnification language and clarify who is responsible for removing the solar panels if they need to be replaced and who is responsible for reinstallation. Ken, do you want to add anything to that?
Well, the statute, and this is Ukiah, and it'll apply to everybody in a couple of years, says that the governing documents can require that the individual owner pay for any extra expenses for the roof replacement. So you should make sure your governing documents do that. That could be as simple as having a rule or a policy, because those qualify as governing documents, and just make it clear. So what Katie was saying is that you can have a specific agreement with one owner when they put solar panels up, but you can also have rules and policies that would apply to all owners, so that if there was a cost incurred because of solar panels on roofs, that could be passed on to the individual owners. Question 2, can you please explain the changes that will occur for all community associations on January 1 of 2026, specifically the open meeting requirements and notices for meetings? So I'll offer that normally I would not get excited or worry about legislation which is in the works until it's actually been adopted by the legislature. And it has not yet been, because we've still got another month or two of process before we could give you any definitive answer on this. What we believe is that the legislature is going to fast forward the compliance requirements for how meetings are conducted and how decisions are made, and make them all applicable to all communities on January 1st of the coming year, instead of waiting till 2028. So there's clearly a group of constituents who are talking to the legislature and convincing them that condo and HOA boards are running amok and doing things in secret, and we need to make sure that all of the decisions made by communities are done in an open and transparent fashion. And we know that we have a lot of clients who do not want to try and hold open meetings or give 14 days notice in advance of any decision being made. But I can tell you that you're going against a legislature which thinks it is reasonable for all of these decisions to be done in an informed and open manner. And so I guess my recommendation would be is start trying to work with what the legislature's requirements are instead of arguing with them about it, because arguing is going to be unsuccessful. So if the current bill as written, which is House Bill 5129, passes, then it is going to move all the open meeting requirements forward. It is also going to modify the open meeting requirements to provide more detail. And so some of the more detail will be that if there is some agenda item to come before the board, which you couldn't have 14 days notice of, that you can shorten the requirements for notice to the owners about what the decision is. But right now it looks like that's still going to require 7 days. And the legislation for Ukiah was already amended, and so this would bring it in for all communities to allow for emergency meetings of the board and decisions to be made without notice to the owners. But the statute has very specific definitions of what qualifies as an emergency under those particular provisions. My short answer is that you'll be required to comply with all the open meeting requirements of Ukiah. Every community will, but those are going to become even more detailed and specific than they are today. Okay. We don't think that they are looking to define the term ministerial, which might give a little bit of clarity to this. But you're not going to be able to use the unanimous email consent in the same way you do now, because it is specifically limited to ministerial actions. And we've come up with a definition of what a ministerial act is for most of our communities that ask, but it is something which doesn't require essentially interpretation or decision making by the board. It's something that's already allowed by your governing documents, or it is to implement a decision that's already been made by the board. There's a question in here about, well, what if a attorney makes a demand and requires that the board respond within 10 days? Well, the short answer is you can respond back to the attorney and say that by statute, the association has to give 14 days notice before it can have a board meeting and make any decisions. So they will just be delayed in the response that they're asking for. And other things which may come out, let's see. We do believe that if you've got committees exercising board authority, that they're going to have to hold open meetings as well. So you can't have the treasurer and board president hold a meeting and decide it doesn't need to be, you don't need to give notice to the owners. If a committee is not exercising board authority, then anything it does is going to come before the main board with a meeting. So we think that you could have that advisory committee meeting without notice to the community. Because in theory, anything that they suggest is going to be on an agenda which the owners get, and the owners would have an opportunity to comment on it before the full board makes any decision. Yeah. Let's see. There is going to be the requirement in Ukiah that boards hold an owner comment period at the start of each board meeting. So this is to make sure that owners have an opportunity to comment before the board makes decisions on action items, instead of at the end of the meeting when it would already be too late for the owner's comments to be considered by the board. So that's another change which looks like it's coming and will be effective on January 1st. Do you have anything else you want to add, Katie?
Just because I have it in front of me, I'll just elaborate on the potential owner comment period in the proposed statute. The statute, if adopted, will set at least a 15-minute time. So it's pretty detailed. You can't just say, oh, we have a 2-minute owner forum at the beginning. It's at least 15 minutes at the beginning of the meeting, and the board can place reasonable time restrictions, not less than 90 seconds per owner. And then if there are 10 owners, you can divide it evenly. So it gets into a lot of detail, as I think a lot of people are concerned about, especially communities that have been closed board meetings, so non-Ukiah, non-HOA Act communities who haven't had an open meeting requirement. It's going to be a shift, so just keep an eye on this statute, because there will be more things that you have to do, but it's all in an effort to, I guess, be more open and transparent, and at least take away the illusion that things are happening behind owners' backs.
I'll also offer that all of this is not going to make any of your owners less apathetic about what the boards are doing. So just because you have to give the owners an opportunity to show up and talk to the board does not mean any of your community members are actually going to do it.
Very true. So the next question, and this is our second to last question in advance. So I know that there have been some questions that have come in, keep them coming. In general, what is the best approach for a condo board to take in fully reviewing all and changing outdated condo documents? Does it require a condo expert attorney to do this if a board does not have the talent to do it? So if you're considering changing your governing documents in any way, we recommend at least consulting a community association attorney and having them involved. This is even if you have an attorney who specializes in a different area of law on your board. There are certain considerations that non-community association attorneys miss. And just for example, like I wouldn't hire a divorce attorney to represent me in a personal injury lawsuit. So I'm not saying that other attorneys aren't experienced in what they do, but there are nuances that may be missed and may be inaccurate. That's if you actually want to go through the process of changing, recording, editing your whole documents if you think they're outdated. If you just want to see what's different or outdated, you can do that without an association attorney. You can just go to the statute if you want to see how it will compare against 6490 in Ukiah in the next 3 years. You can just Google RCW 6490 and read the statute, and the board can do that on their own. You don't need, if you don't want to hire an attorney. That being said, some firms are offering a comparison document or an overview of how your documents will compare with Ukiah and what is outdated. WSCAI may also have resources to help. We've heard rumors of a resource guide coming, but there hasn't been anything produced yet. Ken and I are actually speaking on this at the annual conference. We're looking at the key changes to look for in your old documents and conflicts that may exist. So that's something to keep in mind if you were on the fence about attending the annual conference. And then this is not part of the question, but it's something that we talked about before. In addition to reviewing your documents for how it complies with the statute, it might also be worth specifically looking at the record statute and going through all of your old association records to just purge what you don't need to have. That will help at least reduce like the mental load of all these documents. And so you can go through your governing statute. They all basically have the same language, and review what records you need to keep forever and what records you can get rid of, like old financial records that are over 7 years old. You don't need to keep stuff like that. So that's something you can do without an association attorney. I know it's not part of the question, but something we don't see enough associations doing is getting rid of records they don't need to keep. Ken, anything you want to add?
Well, yeah, the one thing I would suggest and have suggested before is that the board read their governing documents annually to see what makes sense for their community still. So I often think of this usually as about the rules, where you want to make sure that the rules are still appropriate and applicable for your community as it relates to political signs, trash cans, landscaping, pets, whatever it is. And so now you get to look at your documents also in light of some of the statutes. So it's not reasonable to expect you to read all of the statute every year or even once about Ukiah and try and compare it to your governing documents. But there are some very specific targeted statutes that I think are worth reading. So, for example, the meeting section and the voting section of the statutes, which have all been modified in the last 2-3 years several times, and relate to how you conduct meetings and relate to how you can vote, and the ones for electronic notice, those might actually be worth reading because they override your bylaws and declaration. So if you're wanting to know how notice can be provided to owners and you want to use email voting instead of using paper ballots or something like that, it's worth reading that specific section of the statute and deciding whether or not you can use the procedures from the statute instead of what may be in your 40-year-old bylaws. So there is a targeting of many of the aspects of what is coming from Ukiah that you can use instead of having to take on the entire statute all at one time. Anything else on that, Katie?
No, I think you covered it.
Okay, so last question we had in advance is what is the best practice for a condo board in using personal email accounts for communications and conducting condominium business? Should a separate association board of directors email system be in place? So our recommendation is that having dedicated email for the association matters is a good idea. And so you could have, condo association president at hotmail.com or board secretary at hotmail.com. You can have a single board email, which is accessible to all of the board members. And so one of the big things about this is a way to separate all of your communications related to the condominium or HOA from your personal emails. And it also allows an email to be handed from one board member to the next so that there is a history that the new board member can look at of prior communications related just to the community. And, we're seeing more and more of our clients move towards this. We're seeing more management companies move towards emails, which are specific to the condominium or HOA name so that the emails are better managed for the property. And instead of having one giant email box that's full of, I guess, hundreds of emails, the manager does have to go through each of the clients, but that means that when they're looking at one client, they're only looking at emails for that client. One thing which you should think about is if you end up in litigation and there is a request for discovery of the emails related to a condo or HOA, if you've been collecting all of the emails in your personal email, then all of your personal email is theoretically subject to discovery by opposing parties. Or you have the difficult task of trying to sort through every one of your emails in order to decide which ones are discoverable in the court process and which ones are protected. And theoretically, you have to make a list of everyone which is protected and state why it's protected. And it can be very cumbersome, where if you had simply had a separate email for all of the board communications, then you would only have to go through those looking for privileged communications from an attorney. So, you have anything you want to add on that, Katie?
The only thing I thought of is that when you're done serving on the board, if you have a dedicated board email, it goes to someone else and you don't have to worry about an owner coming to you after, say you've sold your unit and moved like across the country. You don't have to worry about potentially getting emails from owners who still think you're on the board, which I don't know. That's just another reason to create a separate email, I think. And with that, we will move into some questions in the chat. The first one is, what are we hearing about using AI for taking minutes? More and more boards are asking about it. So I can tell you what I'm hearing, which is nothing. I have not heard a board ask if they can use AI to take minutes. I don't know if Ken has, but I don't see an issue with it as long as you go back and edit the minutes, because we used AI for something in our office recently and produced a 60-page document for an hour meeting. So it definitely needs to be combed down and checked for accuracy. And so, I mean, I don't know if Ken has a different opinion, but I think it could be a useful tool if you have longer meetings.
Well, I think that there's some very good uses for the automatic note taking. I mean, we use it for this meeting we're on right now, where, but I don't know that I call that AI because it's not doing an interpretation. It's just trying to do a word for word transcript of our discussion. And I think that that is I consider that a very appropriate tool for the secretary to use to help make the minutes a lot faster. The 60-page document that Katie was talking about was us actually trying to ask a computer to summarize or explain differently the information from our discussion. And that's where it can, you know, run into some problems because you get inaccuracies. And then it really does come back to, I think what Katie was saying is how well you are editing the document to correct it. So if you were to, which we haven't tried yet, if you were to tell the computer to take a condo declaration and rewrite it for a 12-year-old to understand, theoretically, AI can do that. But someone would have to make sure that it had done it accurately and appropriately. And I don't know if there's a time savings involved if we went through that process. You know, we have a lot of clients where we do restatements and they want a comparison document. They want to know everything that's different from the old version to the new version. And we've tried letting AI do that, and it produces a very long, more complex document than what we started with. And so at least the AI tools we've looked at aren't there yet to try and solve the dilemma that people have of being handed a 50-page long document and being asked to vote on it. So for something like meeting minutes, I think that automated minutes being taken where it just is transcribing what's spoken, that can be a good start. But also remember that you don't want the minutes to be a verbatim discussion. You want there to be a record of the actions taken by the board. And the discussion and what everyone said is really not relevant to the minutes. What's relevant is the motion made and how the vote turned out. And if a board member has requested that their no vote be inserted into the minutes, you have to do that. But the meeting minutes should be a relatively short document compared to a verbatim transcript of the meeting.
All right, a
Can I
follow-up.
ask a quick question follow up on that?
Yeah.
Sure.
Would you say, I mean, that was my question, and it's really more towards the AI summaries, but when you say like AI transcript, is that encroaching more on like a recording and where recordings would be require everyone's consent?
So I'll offer that recordings of association minutes or association meetings or association board meetings do not require the consent for recording. The statute which relates to recordings for private conversations, and private's the key word here, only apply to conversations where there is an expectation of privacy. And you cannot have an expectation of privacy at a board meeting or at an association meeting. So we get this question fairly routinely during the course of the year is, what about an owner who is secretly recording a meeting? There is nothing illegal about them secretly recording the meeting. And so if someone is taking the recorded minutes or the recorded meeting and turning it into minutes, I don't see any possible violation of law in doing that.
So there was another follow-up question in the chat about this, which is, do you have to keep or can you/should you destroy the notes taken by AI in a Zoom meeting? Don't you have to destroy them or produce them if you don't want them discovered if a lawsuit is pending about something in the minutes? So first, the only record of the association are the minutes. So we've had the question of, can we record a board meeting to help with the minutes, and is that a record? And that's where it depends, what is the secretary using it for? If they're just using it to fill in the minutes and then delete it, we don't think it's a record of the association. I think the same could be said for the notes taken by an AI in a Zoom meeting. If once you have your minutes, that's the official record, you get rid of everything else. If you know that litigation is coming about the meeting, and you say you've already been served with a lawsuit and you don't want them discovered, I think we have a different issue of whether or not you can destroy them. There's something called spoliation of evidence, which you basically can't destroy something if you're in an active lawsuit to not have to discover it. But that's a different question. Ken, I don't know if you have a different opinion on if they can destroy them after they use them.
Well, if you were in litigation, I would suggest not making the minutes.
Or the notes.
It'd be like, this idea that people are taking minutes of executive sessions. And my response is there should be no minutes of executive sessions. You're not supposed to be making decisions there anyway. So it's an opportunity for the board to discuss issues in private, as provided by the statute. But you're supposed to make the decisions in the open meeting. So don't make minutes of your executive sessions if you're in litigation and there's a potential that someone is going to try and discover it. Even if it's got protection under the attorney-client privilege or some other, court rule, I don't know why it would be a necessary document. And I can't imagine AI being helpful in us understanding the discussion.
Okay, so our next question, moving on. I think this one may be a little too specific, but Ken, I'll read it and you can see if there's anything you want to talk about it. Our community has a small stream of water that is moving directly into one of our buildings. The source of the water is from a neighboring apartment complex, possibly a retention pond. Would it be good to send them a letter notifying them of this issue, or contact the county about this?
Well, I would say it is way too specific for us to give legal advice today. We had another client who had an issue of water moving from a neighboring property onto their property. And there's a whole body of case law related to rainwater or groundwater, which moves across from one property to another. And there's a doctrine called the common enemy doctrine, which is about water. Water is the common enemy. And if a landowner does not modify the flow of water, they have no liability for water that flows across their property. So things which we don't know from the question are whether or not the water coming from the neighboring property was always coming from the neighboring property. I mean, if it's a creek, then the fact that it's coming from a neighboring property does not create any liability for that neighbor. And on the other hand, if the neighbor is discharging water that did not naturally discharge, then there may be liability, but you're going to have a lot of specifics. When we're dealing with areas that may be in wetlands or native growth protection areas or are regulated by cities and counties, it's certainly a good idea to talk to the city and county and get information from them about who has the responsibility for the water and also what can be done legally to modify the course of the water. I would also want to look for any kind of recorded documents that relate to the flow of water or easements between the two properties or something else, because frequently there are recorded documents, sometimes many decades old, that predate the community's documents that relate to easements for water, utilities, and roadways. So there's a lot of research that could be done before an attorney could give an answer.
All right. Our next one is, what is the difference between the duty of a board and the fiduciary duty when under declarant control? And is it beneficial for an HOA to adopt the stricter of the two? What are the consequences? I think the question of whether or not it's beneficial for an HOA to adopt the stricter of the two is a question that you should ask your association attorney so they can look at the specifics of what's going on in your community and what are the consequences. Ken, do you want to talk about the duty of the fiduciary duty when it's under declarant control?
Yeah, so fiduciary duty is a different standard than the duty of care required of board members under any of the community association statutes. So the duty of care of a board member who's elected is, that of a reasonable person, prudent person in like situation. The statute puts a fiduciary duty on the declarant appointed board members in that they must act in the best interest of the other owners or of the community. And so their standard of care is higher, and there is a perceived conflict between declarant appointed board members who may be looking out for the interests of the declarant instead of the interests of the buyers. And that's why I think there's a distinction in the statute. So I would say we do not typically see a higher duty of care imposed on elected board members. And I don't know why you would create a higher standard, especially if you're trying to encourage people to serve on the board. I think that it's reasonable to adopt standards or expectations for board members on how they should be conducting themselves. And we do, in the bylaws, which we recommend to our clients, include a code of conduct for board members, which discusses how they should and should not conduct themselves in order to avoid conflicts of interest or the appearance of conflicts of interest. But I would say, as a general rule, I don't see a reason to modify the statutorily imposed duty of care on board members.
Okay, our next question is, what are your current opinions on using reserve funds for restating governing documents for 6490? And I would not say that this is an opinion. I mean, you generally can only use your reserve funds for reserve expenses. And restating your governing documents is not a reserve expense listed in your reserve study. That being said, there are exceptions for when you can use reserve funds for non-reserve expenses. So for example, RCW 6434-384 sets out when an association may withdraw funds from its reserve account to pay for unforeseen, unbudgeted costs that are unrelated to the maintenance, repair, replacement of reserve components. It basically requires that the board notify the owners that this is what the funds are going to be used for and have a repayment plan to replenish the reserves as long as within 24 months, as long as it would not be an unreasonable burden. So in theory, you could use your reserve funds for restating governing documents. I don't know if that would be the path that I would advise my clients to go down. There's no rush to adopt 6490 and restate your documents. You have 3 years to do it. So it would be very easy to either do a special assessment to get the money, or just put it in next year's budget or the budget for the next 2 years so that you can start saving without tapping into the reserves where you may need it for another actual reserve expense. Ken, any thoughts?
Well, I would be surprised that most communities couldn't take care of something like the restatement out of their operating budget, but that's not really important. If you were concerned about it, then one option is wait till the end of your budget year and see how you're doing with your funds. Because some clients have a surplus of operating funds at the end of the year, and you could certainly use that to help fund a restatement. If you have a shortage of funds at the end of the year, then you're going to end up borrowing from reserves anyway. So, or doing a special assessment anyway. So the question to me really is it valuable to restate your governing documents? And if it is, then you look for a way to fund it. If the best way for your community to fund it is to use the reserves, simply notify all of your owners that that's what you're going to do, so that you're complying with the statute.
There was a follow-up question as we were talking about restating, which is, are all associations not formed under Ukiah required to restate their documents? And that one's an easy one. It's no, you're not required to. You can. The statute's going to change regardless. It's going to trump whatever is in your documents. So you can restate to avoid a conflict, but you are not required to.
Right. The fact that your bylaws do not require open meetings is not going to change the statutory requirement for open meetings. But you don't have to rewrite the bylaws if you don't want to. You just have to hold the open meetings.
Great. This next one is a homeowner who does not serve on the board or a committee has volunteered to conduct regular inspections of properties to identify violations or issues that need to be addressed. He plans to forward his findings to the manager. However, he is not interested in joining the board. Is there an alternative way to allow him to conduct these inspections without having to join the board? I mean, he's not taking any action for the board, so he can report whatever violations he sees or issues. The board is still the one making the decision. So if if he doesn't want to serve on the board, I don't see a reason why he couldn't keep just reporting all of these things to the board and then let the board decide if it's worth a violation notice or taking any action.
I suppose in theory, an owner could be reporting violations of other owners with no connection or affiliation with the board or management anyway. And I think that the board, whether independently or through management, does need to have enough information to verify if a violation has occurred. But I suppose if photographs were supplied, that might be enough information to do it. So it kind of, we don't usually have people volunteering to be the HOA police, as it were. And I guess it really depends on whether the enforcement action complies with the requirements of RCW 6490, 405, I think it's sections 7, 8, and 9, which is the section of Ukiah that says that the board gets to decide what enforcement action to take and whether it is reasonable and in the best interest of the association. And that just because they don't take action in every instance does not mean that a covenant has been abandoned. So, if an owner wants to be helpful and report violations, I don't see any reason that couldn't happen, but it does still require that there be board decisions before fines are assessed or other enforcement action is taken.
So the next one in the chat is, if a homeowner requests to install an EV station, does the association have to accommodate the request? Does the homeowner have to pay for the upgrade? So first, of whether or not the association has to accommodate the request is going to depend on where the person wants to install the EV charger. As we talked about with the solar panels, there's a difference between installing something on the common elements or in the common elements and a limited common element garage or parking space or even the unit. So if it's in the common element, usually the answer is no, it does not have to be accommodated. Again, the board could decide to accommodate it, especially with the growing number of electric vehicles that we're seeing. We're getting more and more requests for installing chargers in either limited common elements or common elements. The statute does say that the owner can be made responsible for upgrades, though whether or not that's reasonable or actually practical is a different story. Sometimes it is a hefty expense to increase the electrical capacity for the entire association, which is what is usually required for if there's not enough capacity for this one EV charger. So making one owner pay for something that would benefit the entire association is unfair. So if that is the case, that's where you should decide what you want to do with your own association, and talk to your association attorney. In terms of other costs, you can still require owners have insurance. You can require that the association be named as a covered party on the insurance policy. And you can also require that the owner pay for all electricity, not the upgrade, but the actual electricity servicing the charging station. As we talked about with the solar panels, we recommend a policy for EV charging stations, their installation, how upgrades will be handled, and even a hold harmless agreement to deal with how this will pass on to future owners. Ken, do you want to add anything?
No, I think the short answer is we recommend the client find a way to accommodate EV chargers. But yes, the individual owner is responsible for all the costs of putting them in and using and maintaining them.
Yes. Okay. The next one I think is a clarification. Is there an RCW that states not to take minutes in executive session? I have a board that regularly takes minutes in executive session. I don't know off the top of my head if there's a statute, but I think because no action can be taken in executive session, it has to be taken in the board meeting, and the minutes only reflect the action taken by the board. There's no minutes of the executive session because there's no action.
So the records statute, which was adopted 2 years ago, I think now, at first it lists what minutes must be kept, and it does say you don't have to keep minutes of an executive session. It doesn't prohibit you keeping minutes. It just says that that is not a required record. And then it also says that minutes of executive sessions are to be redacted from the records which are provided. So the minutes in executive session are mentioned twice in the statute, once under records to be kept and once under records to be provided to owners.
Okay, we have one more in the chat, and I think it's going to be too specific, but we'll see. I'm a little concerned about how our management software is going to work with the open meeting requirement portion of Ukiah. Example, currently a homeowner can submit a late fee waiver request through our online portal that goes to the manager to review and then on to the board to vote. The software captures the records and keeps them into perpetuity. The same process applies for an ACC application. I'm concerned that using our software after January 1st will be a direct violation of the requirement that all decisions be made in an open meeting. So as we talked about before, what's important is that the decisions are made at an open meeting. So if you get an application through whatever management software or portal for an architectural control request, you can still submit them through there. It's just that the board discussion and decision about whether or not to approve it has to be taken at a board meeting, not over the software. So if you have a advisory committee that reviews ARC applications and makes recommendations to the board, but not an actual board decision, that would not have to be an open meeting because they don't have any board authority. They're advisory only. So I'm not sure how the software works all the way, but it's the board discussion and the board vote that we don't think can happen on some electronic platform or over email. But anything that's reviewing or advisory or forwarding it on for the board's review at a board meeting would not conflict with the statute.
Yeah, so for me, this is a records question, not an open meetings question, because the records statute does say that you're supposed to protect records related to individual units from review by all other units. And so if you had an ACC request, I don't think that that can be put on a publicly available portal for all owners to see, even if the decision for the ACC request has to be done in an open meeting. And so there are going to be some challenges, and we don't know what they all are, in how the clients and managers comply with both the requirements to have records available when requested, the requirements to redact certain kinds of records, even though they've been requested, and what's practical in record keeping. We're certainly seeing more and more clients move towards 100% electronic records, but there does have to be a way of segregating the access that the general public has to the records, the individual owners have to the records, the board members have to the records, and then what the manager has access to in the records. And most of the software which has been prepared for management companies probably originates out of Washington State. And so it was not written to comply with our statutes, and then it was not modified to comply with our statutes as the statutes have been changed every year. So that can be a problem. I mean, I know that we have some management companies that spit out violation notices, and the violation notices do not comply with Washington State statutes. And we run into this routinely in our collections practice where someone is trying to collect money for a fine, and we discover that the fine notice did not comply with the statute. And so we tell our client we cannot collect the fine. And our clients always get upset. And, you know, I don't know how to get the software package from some other state, which may be fully compliant with that other state, to be modified so that it is compliant with our statutes here. So, you know, I don't know the answer and how to direct clients or managers to best comply with our statutes. And especially the record keeping, because I do think that moving towards websites to hold records is sort of logically the easiest way to comply with the obligations to make records available to owners. But I also would want to make sure that you're not putting everything on there and then violating the section which requires you redact specific information. So, yeah, I don't know the answer, and I don't know who you find as a consultant to help modify the software so that it is both compliant with the privacy requirements of the statute and the open disclosure requirements of the statute. Any other thoughts, Katie?
Nope, I think we've covered it. There were a few questions that were submitted in the chat that are too specific for us to even address generally. If you want to try and reframe them for next week, feel free to send any questions to info@condolaw.net. I think we will call it here a little early, give you 4 minutes back of your day. We look forward to seeing everyone next week, and thanks for coming.